This is the common lecture for Year 3 medical students. The topic of today's lecture is Child Act 2001 and other acts related to child protection in Malaysia. Please note that all material used within the slide and this lecture are copyrighted items and do not reproduce without my permission. I would like to bring your attention to the Child Act 2001, which is the most important law with regards to child protection in Malaysia. Before that, let's have a simple question time. Who do you think needs to know about Child Act 2001? And option A to E are provided. Now, I reckon that all law-abiding Malaysian citizens are supposed to know to some degree the Malaysian law, and in my opinion, Child Act 2001 is often one of the more neglected law in Malaysia. And therefore, the objective of this particular lecture is to make you aware about this particular act, especially you will be becoming a doctor, you will be dealing with children in your career. First, let's define children, right? At what age that we say a person is defined as a child by law? According to the Child Act 2001, a child is defined by anybody who has the age less than 18 years, while the definition for child abuse and neglect is provided by the World Health Organization. So it could be physical, it could be emotional, it could be sexual, neglect, or any form of exploitation, okay, and leading to potential harm to the child's health, survival, development, and dignity. Well, another question time. This is basically just a general knowledge. What do you think is the composition of children in Malaysia? Alright, so you may have a figure in your mind, and let's just look at the statistic. Okay, this is the latest statistic provided by the Department of Statistics, Malaysia. So the population of children, those less than 18 years of age, okay, makes up about 27.9% of the general population, okay, which is about 9.13 million. That is in 2021. The figure is slightly dropped compared to the figure about 3 years ago, which is 2018. Back then, it was reported to be 29%. Now, zooming into Child Act 2001, again, it is quite a comprehensive document, and I'm just going to highlight certain important points that probably would be relevant to a medical practitioner and what matters to a person dealing with children. Now, the most important content within this act would be helping to define the crimes against children, okay, and what the procedures there is for us to when we identify a child that is a victim of a crime. Okay, within this act itself, a number of items are being covered. Okay, so you can see from the list given in the box. Okay, that including things like even if a parent allow a child to beg and to perform some illegal activities, okay, then the parents are actually punishable by law, and this can be considered a crime against children. Now, the crimes against children, of course, I think we have mentioned earlier. So it could be a variety of different abuses, neglect, or even some form of exploitation. Right. The first important message that I need all of you to know would be your role as a medical professional to be, or medical practitioner to be, on notification. Now, realize that as a medical practitioner, if you have any suspicion that a child is being abused, okay, or is a victim of any sort of crime, then you have the legal responsibility to notify to the authority, namely either the police officer or the child protector under welfare department, Jabatan Kebajikan Masyarakat. Yeah, so failure of which, okay, meaning if you fail to notify despite having find suspicion that a child is being abused, then you are liable for punishment, a fine of 5,000 ringgit or even jail time of less than 2 years. Yeah, so that again, but it doesn't only include medical professional or practitioner. It also include people like childcare providers, teacher in kindergarten, school teachers, and immediate family members, and so on. So as I said, notification can be done either if this is an if there's the element of crime, then a police report should be made, and we must also report to a child protector according to the Child Act 2001 to the child protector specific welfare officer that is in charge of children who work under the welfare department. Okay, this is Borang 9, which is the form that we use to notify to the child protector. Okay, another way that we can also find reporting done would be through this hotline called Childline. Okay, and the number is 15999. Now, this was previously separated, a separate entity, but it was incorporated into Talian Kasih. As you know, Talian Kasih is hotline started by the Women, Family and Community Development Ministry for the welfare of the given group. So this Childline was actually incorporated back in 2010. And since then, for the next subsequent 5 years, an average about 18,000 calls has been made. Okay, that's roughly comes to about, if my calculation is correct, is about 3,500 calls per year. That's quite a huge number, and I'm pretty sure that the number has increased over the past 2 years, especially since the COVID-19 pandemic. Now, back then, the statistic shows that the average age of children who made the call are usually teenagers, but they do have the youngest child who make a call as young as 5 years of age, and the majority of them are mainly reporting them to be having mental problem, psychosocial issues like loneliness, depression. But it's important to note that 20% of the call are actually self-reporting of them being abused, be it physical, sexual, or both. Now, following notification, the Child Act 2001 also highlight what we do with children in terms of their subsequent care and placement, and if it involves elements like physical or sexual abuse, then medical examination ought to be performed in a hospital by a medical professional. So this is usually done by what we call a SCAN team, suspected child abuse and neglect team in a particular tertiary hospital. Yeah, and this topic will be discussed again in year 5 in one of the seminar. Now, I would also like to highlight here in this particular box over here that often in situations when a parent refuses to give consent to a child that is requiring treatment, okay, Child Act can also be activated. This is especially in the case when the life of the child could be in threat as a direct result of the parental refusal for treatment. Then Child Act can be activated, and in fact there is already precedence in Malaysia, which I was involved, and Child Act was activated, and a protector came in and took temporary custody of the particular child, and subsequently the child protector authorized that particular life-saving procedure. Okay, so in those kind of circumstances, really when we're dealing with a life and death situation, and for whatever the reason, okay, parents refuses to give the consent for the necessary life-saving procedure, then this is one of those circumstances that Child Act can be used. Okay, this is just the following the previous slide as to with regards to the care and placement of the child, and also medical examination needed. Okay, for more detail, in fact, you can actually download the entire Child Act online. Okay, and of course, medical officers or medical professionals, it could be private, it could be government, it could be university doctors, it could even be a military doctors. Okay, we're all bound by the same law. Of course, a child means anyone that is less than 18 years of age. Okay. And this law, despite being enacted in 2001, it underwent a major amendment in 2016. All right, and I would like to highlight a few important points. What are the important amendments made back in 2016? So number one, heavier penalty has been given to the offenders, okay? And before the amendment, a child can be actually being caned as one of those punishment, yeah? But this has been abolished, okay? Secondly, I think that there is a requirement to set up a child registry, meaning those perpetrators or those that have already been charged to be a child abuser, we will need to keep them under registry to monitor the activity. And similarly for children who are victims of abuse, we also need to make a registry to keep them in record and follow them up. Okay, so emphasize a lot on community service order, especially for minors who committed offences. Okay, and we emphasize family as remember in the care and placement column in the previous slide. So we do emphasize the importance of family in this case. So not all children will need to be placed in a welfare home, for example, and so on and so forth. Okay, but unfortunately, the issue of child marriage was not addressed in this particular amendment. Okay, understandably because of a lot of social, cultural, spiritual arguments and as under debate. Now, that is pertaining Child Act 2001 and the recent amendment 2016. I would now like to bring your attention to the second law, okay, second most important law that safeguard the children's right in Malaysia. Now, around the year of 2014, 2015, 2016, a number of events have occurred and that have directly or indirectly led to this new law being formed in Malaysia. Okay, the first one probably is some of you may have heard in about 2014, 2015. This British man named Richard Huckle was found to be guilty of abusing sexually, okay, many Malaysian children, hundreds of them. Many of them are from the extreme poverty. So this man basically is a wolf who dress as and disguised as a preacher who go around hunting for these young victims and use his figure and so-called as an authority and with the intention of actually abusing them. Okay, and this guy was actually found guilty and sentenced to 22 years of jail and in the UK, and in 2019 this person was found to be killed in prison. And in 2016, 2017, okay, this particular group of journalists called Rage, okay, which is under Star Media Group, published a very powerful documentary titled Predator in My Phone. And I strongly encourage all of you to watch this particular documentary. You can go to YouTube and type Rage and Predator in My Phone, and you can really see what is going on behind the scene and behind our public eyes in terms of sexual grooming and sexual predators in Malaysia, which is really mind-blowing. Okay, all these events have led to this bipartisan support of this particular new bill called Sexual Offences Against Children. Okay, and it was one of those rare events when the ruling party and the opposition can stand together on stage together and support, okay, a common cause, in this case against children's sexual abuse. With this, the Sexual Offences Against Children Act 2017 was tabled and passed in April 2017. And I would like you to now watch this short video, about 3 minutes, just to summarize to you what this act is all about. And again, this is taken from the Rage website. Okay, I shall play the video now.
You may have heard of the Sexual Offenses Against Children Act 2017. It's a new law that provides for stronger protection for children against sexual assault, including sexual grooming, which Rach helped push forth through our Predator in Our Phone series. It was passed in Parliament on the 4th of April and gazetted on the 7th of July, which means it is now in motion. Here are the things you need to know about our new laws. 1. We finally have laws against sexual grooming. Sexual grooming means befriending a child with the intention to commit a sexual offense. So if you're the kind of guy that likes to go, hey, boleh jadi kawan tak with an underage child? This one's for you. 2. Failure to report a crime is a crime. If you witness a crime and you fail to report it, you could face up to 5,000 ringgit in fines. 3. Higher punishments for people in positions of trust. That means parents, teachers, doctors, anyone who's supposed to be protecting the child in the first place. When these people commit a crime under this new law, they will be punished harsher, with an additional 5 years and a whipping of no less than 2 strokes. 4. Evidence of a child witness can now be admitted uncorroborated. In the past, courts used to admit the testimony of a child only if it was corroborated by other evidence. That's because children make things up, like Santa Claus, sexual assault. Only experts tell us that sexual assault is the one thing children almost never lie about. They just don't have the context to make things like that up. Now, evidence from a child is presumed to be credible by default. Of course, the law does make the court responsible for first finding out if the child is a reliable witness. 5. Evidence from agents provocateurs are admissible. Evidence given by someone who went undercover can now be admissible in court. This gives police the incentive to go out and nab a predator. But it also brings up issues of entrapment. 6. Child porn. We already have laws against porn in general, but with the new law, it's going to be a much bigger crime to watch, sell, or make child porn. Anyone caught making, selling, or watching child porn can face up to 30 years in jail and a whipping of no less than 6 lashes. Right now, just watching or selling normal porn could land you a fine of up to 10,000 ringgit, so that's important to know. 7. Sexual offenses against a child now include non-physical sexual assault, to which we say, about time! This includes exposing a child to anything sexual, either through speech, action, or visual representation. 8. Presumption of age of a child. Sorry, but she looked 18 is no longer a viable defense unless the offender took all reasonable steps to find out the age of the child. 9. Sexual offenders will now be put under police supervision for at least 1 year and at most 3 years after their release, which probably sucks more for the police officer than it does for the offender, but it keeps us all safe.
Okay, that would be the Sexual Offences Against Children Act in brief. So I hope you all can understand what is this new law all about and is currently already in effect. Now, the next portion of the lecture I would like to bring to your attention and maybe just stimulate your thinking on the current challenges and current shortfalls and limitations that we have pertaining to Child Act and also other acts on child protection. Now, the first thing that I'd like to highlight is, again, throughout the past, many years that I've dealt with children, there is this persistent lack of awareness on Child Act, and sometimes really, is a downright reluctance to use Child Act as a law, powerful law to protect, to safeguard and protect children. Now, that is the whole point of me having this particular lecture, so that young doctors can now be aware that this Child Act exists and the content of this particular act in brief, especially what you are expected and your responsibility as a medical practitioner. Okay. The second challenge that I managed to, in my opinion, would be the archaic or the very old-fashioned narrow definition of rape. Now, I'll give a few examples. Yeah. So again, in 2015, many things happened in 2015. So a man in Sarawak was actually acquitted from his charges of raping a minor, I think it's 16 years old girl. back then, because what happened was he inserted his finger into the girl's vagina and fill up with his own sperm, and actually causing the minor, the girl, to be pregnant. Even though the subsequent newborn child was tested through DNA test that the father of the particular child was actually this man, but yet this man was acquitted from charges of rape simply because back then the definition of rape was defined in law very narrowly as penile penetration. Okay, and because this one is using finger, and therefore the charges of rape could not stand in court, and this is as laughable and furious as it seems. This is happening. All right, and fortunately for this particular case, together with the SOSC Act 2017, okay, the Parliament has actually amended the definition of sexual offences. In this case, also including any form of sexual activities or acts. Okay, not only penile penetration, but including the other definition as well. Now, but still, if you look at the definition of statutory rape, okay, what is statutory rape? Meaning rape, okay, that is defined by law, and in this case, the definition is sexual intercourse with a girl under the age of 16, okay, whether or not she has given the consent. Again, the age here is less than 16, so if, again, this has direct contradiction to the Child Act of 18, that's issue number one. And do you realize the second issue here of the definition of statutory rape is the gender, okay? So again, it's very specific that a girl, and it's a sexual intercourse, even though now it's a sexual intercourse, the definition of rape has been revised, but under this particular type of rape, statutory rape, on those happening to those girls children less than 16 years, in the law currently is still narrowly defined as a girl. In other words, if a boy less than 16 years and being sexually assaulted, okay, that has not been considered as statutory rape, which is, again, think about it, not logical, and yet this is the state of the law today. Now, the third thing I would like to bring to your attention would be child marriage. Now, everyone would have their own opinion on this particular very touchy subject, but I just want to bring to your attention again that to some statistic and what is happening in Malaysia. So worldwide, 12 million girls are being married, okay, when before their 18th birthday, okay, and in Malaysia it's estimated between 1,500 to 2,000, and I still think this number is an underestimate, right? So that you can imagine in a day how many underage girls are being married off, okay, before they reach their 18th birthday. Now, there might be some opinion as to the positive points of this sort of marriage, okay, but the hard facts, okay, the statistics, the researchers have again consistently show that if a girl is being married off too young, especially when they are still considered a child, then they are often a victim of domestic violence. That's number one. Number two, because they get married so early, and many of them do drop out from school, and subsequently they are trapped in this vicious cycles of poverty. Okay, again, we know that education is important to uplift the socio-economic status of a person, right? And because they're so young, they're still understanding their body, their biological changes, the physiology, okay, and so there would be a lot of issue during their pregnancy, the process of childbirth, and subsequently for the care of the young infants as well. Okay, so I even have personal experience whereby young mothers have very small babies that brought in a severe condition and subsequently died. So these are the really problems that we face, especially towards young mothers. Okay. Now, the next thing that the potential challenges, the potential challenge in Malaysia would be the use of child registry. Now recall that child registry is one of the new changes, a new addition to the Child Act in 2016, okay? And during the Pakatan Harapan administration in 2019, it was formally launched by the then minister and deputy minister. You can see in the picture. So, but it is yet to be seen how effective is this particular registry in helping us to control and to safeguard the welfare of children. Okay, and I have not really heard about any news about this particular registry since then. Okay, as we speak now in 2020, early 2022. Well, the next thing which I think is still perpetual and is still ongoing would be the severe shortage of gazetted welfare officer or child protectors. Now recall that child protectors are specially trained welfare officers from Jabatan Kebajikan Masyarakat that they are specifically trained to deal with this group of children under abuse. Okay, and mind you, it's obviously not easy to be a child protector. Now, what do you think is the number of child protector gazetted, meaning they are approved child protector in Malaysia? Okay, the 2018 figures is less than 210. Now, if you look at the figures of reported child abuse in Malaysia, averaging about 5,000 a year, so you're looking about roughly about 15 to 20 reported abused children, and this number is actually underreporting, mind you. So if we take this particular number, okay, in a year and divide by 208, so what do you get? You have one child protector versus 80 cases every year, and some of the cases drag on for several years, so the number can pile up quite rapidly. So this is the burden of, as we stand, the burden of a child protector in Malaysia. Okay, so what is and if you look at the population of Malaysia, 29 million, so one child protector towards almost 50,000 children. Okay, so that is the amount of work they are currently facing. Okay, so what is our target based on our population? We need about 1,000, so we are only achieving about less than 20% of what our target is. And this is the state of our child protector currently. Indeed, back in 2013, in the Child Protection System report by UNICEF, has repeatedly highlighted the issues of undertrained, untrained, and the low number of child protectors within the country. I'm sure we have progressed rather significantly from 2013 until now, but still I strongly believe that the number of child protectors still is inadequate in Malaysia. And lastly, and this is an ongoing challenge, and we have still yet to see what we can do comprehensively, because things are still changing rather rapidly, especially after the past 2 years of all of us trapping at home due to the COVID-19 pandemic, and children have significant increased screen time and exposure towards screen, different media, different social platforms, okay? And with the emergence of new social media platform, for example, we are talking about TikTok, we're talking about even Facebook talking about virtual reality and augmented reality. Now, these are all the new platforms that could be a potential place for online child sexual exploitation and abuse. Now, on that note, thankfully, the Malaysian Communications and Multimedia Commission has been quite proactive in this sense, and they are looking into areas to bolster the online child protection efforts, and it's yet remain to be seen how the effect of the actions and the measures. Okay, and again, this is something that is rather new, and we need to keep a close eye on the newer development. All right, so finally we come to our final slide, which is a summary. Now, I only have 3 take-home message for all of you. Okay, number 1, as a medical practitioner to be in training, okay, you must, I say you must be aware of the laws pertaining child protection in Malaysia, okay, and especially Child Act 2001 and the new Act, Sexual Offences Against Children 2017. And I would strongly urge all of you to not only be aware but also be advocates, be the champion of child rights and child protection. The second point I would like you to take home with would be your duty in future as a medical professional. And very important, you must have the skill and knowledge to identify a child being abused, be it sexually, physically, or any forms of other child abuse. And you must know your responsibility to notify to the authority when you suspect such a case. Okay, again, this topic will be revisited in year 5 during the seminar on child abuse and neglect. And lastly, I do spend a quite significant portion of my lecture talking about the challenges, the shortfalls, and limitations in existing laws. All of you should understand, continue to follow up the progress, and to update yourself on these areas. With that, I will end my lecture, and thank you all for your attention.